What's up, everybody? What a absolutely wild week. I don't even know where to begin. We have obviously a lot of ashes of creation stuff that just got dumped onto us. A massive filing by Stephen Sharif looking to have a receiver appointed, which is what we're going to get into. But just, gosh, 64, I think, exhibits, texts, emails, declarations from former employees, investors, just all sorts of stuff, accusations of threats and intimidation, apparently trying to kick him out of his house. A whole bunch of stuff just got dumped into our laps to try to sort through. Gosh, even Karen, not the Discord Karen, but the actual Karen Boyko also provided a declaration. And wouldn't you know it, the riot conversation was at least real. We don't know how far it actually got, but it was real. They even actually put out a statement on Twitter about it. So just a lot of stuff for us to kind of try to work through. And in addition to that, Stephen releases this ginormous statement, which you have to go check it out if you haven't. I'll put a link in the description. So just a lot of stuff is going on. We're probably going to have to break a lot of this down into more than one video. This one's going to be more sort of explanation of what the actual filing is for this receivership. You know, there's a whole lot of other stuff in here, some financial information, some, again, the riot stuff, a lot of other things that we can probably break into separate videos, just so that I'm not talking here for like an hour. But it's been an absolutely wild week, and I've been super busy at work too, which has made it challenging to try to read and put everything together. For all of those of you that have been asking that do not have it yet, I'll put a link in the description to a zip file containing everything. It's a lot of stuff, so it has to be a zip file, but I will put a link into the description for that and anything else that I happen to talk about as well. Because like I always say, do not trust me, bro. Go read for yourself. As we get started, I do want to talk a little bit about this idea of how the lawsuit has been filed, because I've been getting a lot of questions of what is Stephen even asking for? What does he even expect to get? And part of that really breaks down into this idea that he has filed this on behalf of himself, but then also as a derivative claim on behalf of Intrepid Studios. So those are two separate, although somewhat interconnected ways to file this, because, you know, Stephen himself obviously representing himself, but then he's also an investor in Intrepid, owning 5% or whatever it is. And so he's able to file this derivative claim. So if you really want to know what he's trying to get out of this, that's actually kind of easy. I'll put, again, the link to this document in the description as well, and just go back to his original filing, the complaint. There is a prayer for relief there, which basically spells out everything he's asking for. You know, this self and derivative claim thing is important, because that does actually help us understand what they're asking for. When you look at things like compensatory damage, punitive damage, stuff like that, money essentially awarded, you know, that's going to be likely going under himself, right? Looking for some sort of financial recuperation. But when you look at the things that say wanting the company to adopt and implement a whole new corporate governance, getting rid of the current board, trying to prevent the defendants from using or selling any of the company's trade secrets, those are things that are actually more under the derivative claim. Now they, again, get filed together because they do overlap, and so that's not unusual. But I just wanted to mention that as you're sort of working your way through and understanding what's happening and why certain things are being posted and shown, kind of try to understand the difference between self and derivative. We are focusing a lot on the Stephen Sharif side, the personal side, because where all of the juicy details and all of that stuff happens to come from. But it's equally important to sort of pay attention to this concept of a derivative claim, because that actually might get more out of Intrepid Studios as far as change than Stephen's self-claim. So, all right, so this whole motion was to ask a judge to appoint a receiver. Now, what exactly is that? Well, it's essentially, you can think of it as a court-appointed CEO. with emergency powers. So the plaintiff's team, Stephen's team, has suggested a gentleman named Howard Grobstein. And they've also asked that this receiver have a lot of authority. So authority to do things like take possession of company assets, to control operations, manage finances, conduct accounting, litigate claims, really ensure compliance with court orders, and then sell assets if necessary as well. So a long list of sort of authority given to this individual person. And this was actually, they asked for this to be a May 19th hearing, although we also have now got an ex parte to basically speed up the motion. So we'll see if the judge actually grants that or not. But this is essentially what's being asked for. And again, I mentioned it's this gentleman named Howard Grobstein. They actually did include his CV as well in the exhibits. Looks like he's a CPA with a lot of experience in fraud and forensics, is a certified fraud examiner, and has numerous cases listed. And I guess has some sort of previous interaction within the sort of video game industry, which is partly why they asked for him. Keep in mind, we did have a previous intellectual property custodian that was appointed as part of the initial TRO, which has now been extinguished. That was a little bit different. That was just more so containing assets, controlling who got access to certain things. Didn't really have all these other powers that they're asking for. So it is different. So as we get into this, I think it's important to really understand what is the success chance here? What is the likelihood that this gets granted? And from everything that I can see, it's actually pretty rare. Even less than a preliminary injunction, which was denied. Most of these that I found are denied. So you do have to make very clear the risk factors that are involved, and it has to be very strong evidence, really multiple risk factors. Things like fraud, misappropriation, insolvency, the risk of a destruction of company assets. It has to be very clear as to what's occurring, and again, very strong evidence. Interestingly enough, we did also get to see some emails as part of the exhibits, and this was obviously discussed by the plaintiff and the defense prior to bringing this to the judge. The defense was actually agreeable to a receiver, but with much limited power. They did not agree to the amount of power that was being requested by Stephen's team. They basically proposed the limited power of holding, collecting, and organizing the IP. They really did not appear to have any interest in anyone being able to tell them whether or not they could sell things or litigate and stuff like that. All right, so what's the legal standard that Stephen's team is going to have to demonstrate in order for a judge to agree? Well, this seems to really fall down to a case called California Life Assurance Company versus Lapeter, which came out of the Ninth Circuit Court, which is what does cover California, which is where this is at. And essentially, they basically stated a court has broad discretion in appointing a receiver, and that it may consider a host of relevant factors, which we're going to cover here in just a second. But from what I can see, if there is a question of appointing a receiver in federal court in the Ninth Circuit, this seems to be the case that is most always cited. So this is why they focused on it, and it's what we're going to go over. So the Ninth Circuit has identified several factors that are relevant to appointing a receiver. And Stephen's brief does actually touch on basically all of these. One of them is whether the party seeking appointment has a valid claim. Two is whether there is fraudulent conduct or the probability of fraudulent conduct by the defendant. Three is whether the property is in imminent danger of being lost, concealed, injured, diminished in value, or squandered. Four is whether legal remedies are inadequate. Five is whether the harm to the plaintiff by denial of the appointment would outweigh injury to the party that is opposing appointment. Six looks at whether the plaintiff has probable success in the action and the possibility of irreparable injury to the plaintiff's interests in the property. And seventh is whether or not the plaintiff's interests will be well served by the receivership. So also the Ninth Circuit basically said that while these factors are relevant to a court's determination, there's ultimately no precise formula for determining when a receiver may be appointed. And further, they actually also stated that the availability of other remedies does not in and of itself preclude the use of a receivership. So even if there might be some other ways to remedy a claim, you could still appoint a receiver. So essentially, the judge is given very broad latitude in assessing whether or not this is going to be granted or not. There's not a very strict test which they use. So with this, part of all of these documents, the 64 exhibits, they actually included quite a lot of statements from Intrepid shareholders, creditors, and former employees that all support the appointment of a receiver. And all of those provided statements. Again, stuff that we'll probably look at later just because of the sheer volume of information. So Stephen's team broke this argument basically into 4 different points that they state really should urge the judge to side on their behalf and establish a receivership. The first of which is that they feel the plaintiff is likely to succeed on his claims. And so what they mean by this is that they feel that it's likely that we will see a success in the derivative claims filed against the Board of Defendants. And again, this is partly why I brought up earlier this idea of filing on behalf of oneself and then also as a derivative claim and how that matters here. And so what they're saying here are things that we've really already seen. One is that there's been a misappropriation of trade secrets. 2 is that there was this wrongful foreclosure done under the California Commercial Code. And that even with a reversal of this, which has happened, the damage still happened from this, and it was still considered unlawful. And so another thing they talk about is this idea of a breach of fiduciary duty. And so with this, they cited several things that they claim damaged Intrepid Studios, one of which was this creation of a pathway bank account without approval. 2 is the threatening of homelessness to Stephen and John. 3 would be accumulation of debts. So there's a lot of hearings, SATA systems, and some others that are out there that have accumulated in debt that are now turning into court cases. And then there are this idea of this Warren action that occurred and that the company is now being looked into that. And then there's also the class action suit by the former employees. So all of this together has been defined as this idea of a breach of fiduciary duty to Intrepid Studios. And so what they're saying is that if we're going to look at this candidate case as a way to establish a receiver, that these claims will satisfy the first point, which is that the plaintiff has a valid claim, and also the first half of the second one, which basically states that the plaintiff is likely to be successful. So the second point is that they're claiming the plaintiff will suffer irreparable harm absent a receiver. And so the plaintiff here being Intrepid Studios. And so with this, what they're basically stating is that the defendants are poised to conduct an asset disposition, a second sale. Now that they reversed the first Article 9 foreclosure, there's been these comments or possibilities of doing a second one. And here the argument that they're making is that if that's the case, it would be illegal. And also because of how everything is set up, that no rational third party could barely participate in it because of how the credit bidding is structured, which we'll get into. And then when looking at this, and again, going back to this Canada case, they're basically stating that this also satisfies 3 more different elements of that. One of which is that the property is in imminent danger. 2 is that there's inadequate legal remedies. And then the other one being the possibility of irreparable harm to the plaintiff. And so this one gets a little bit more detailed as to the conversation pieces. And I actually find a lot of it be a kind of interesting. This actually goes into what we talked about in our last video, which is this idea of a second foreclosure and the risk associated with that. And so they're trying to make this very interesting argument that there really is no legal basis for a second foreclosure, and that this is a reason they really want a receiver, is to make sure if this occurs or if they try to do this again, there's someone in place that can really vet it from a legal standpoint in either allowing it to happen or denying it. And what they cite here is the California Commercial Code, specifically 9617A. And what that code states is that after a foreclosure sale, the lien is extinguished. Specifically, it's a foreclosure sale, quote, discharges the security interest under which the disposition is made, end quote. And so they're looking at this basically stating that the first foreclosure happened. Now there was a reversal, But because the first foreclosure happened, they no longer have the lien. The lien was discharged, so they couldn't do a second foreclosure. And so they further actually make reference to another element of the California Commercial Code. It's 9625A, which actually does have to deal with what the court can do or how they can remedy an unlawful sale. And that is going to be things like stop a foreclosure sale, delay enforcement, set conditions for the sale, issue an injunction, appoint a receiver. And they go on to state that of these available remedies, none of it includes that the foreclosed upon lien can remain in effect or does remain in effect. So again, they're using this argument to say the lien no longer exists. Is that real or not? I don't know. I guess a judge will have to figure it out. I do think it's an interesting discussion point. I'll be very curious to see what the judge has to say when we get the transcripts. And so Stephen's team also commented on the specific case that was used by TFE to reverse the sale, basically saying it shouldn't apply here. And the rationale, just so you understand it, hopefully, is that in this specific case, it was called PWS Inc. versus Ban. One, they commented on this as like a 34-year-old case, so it's old, and that it's by itself. There's only one case. But in this instance, the secured creditor conducted the foreclosure sale on the wrong date that rendered its notice defective. And hopefully you've seen from our previous videos, there are very specific ways that you have to go through an Article 9 foreclosure sale. One of those is how you advertise it. And so here there was just an honest mistake that rendered the notice defective because the foreclosure sale occurred on the wrong date. And so immediately upon realizing this, a second sale was conducted with proper notice. And so the judge basically said that that was okay. And that was this idea of a reversal. However, what Stephen's team is trying to state is that TFE Games did not make any sort of accidental mistake, that they were very intentional. That's what they're claiming, that they knew what they were doing. They were trying to get around the law and they got caught. And after they got caught is only then when they tried to rectify the issue. And so they're stating that really, in this instance, this specific case really shouldn't have applied to them anyways. Again, an interesting argument. I'm not a lawyer. I don't know how this ends up. They also talk about this idea of a credit bid problem, which is something that I will probably do a whole another video on because it starts to get into a lot of the financials, which I also find kind of interesting. So essentially, what this is that when you have this sort of bidding process, this Article 9 foreclosure, you can use a credit bid. So if, let's say, you owe me a debt of $5 million, well, then I can actually bid that $5 million on your company, and I don't have to pay with cash. And so what they're stating here is that TFE claims to have tens of millions of dollars of secured debt, which they can then use to bid on the assets. And they're basically stating that this chills the competition and makes really third-party interest almost non-existent. And then they go, again, further to question whether or not they even have secured debt. This, again, gets into this whole idea of some of the contracts exercising a conversion to stocks, but then reverting back to debt, but not returning all the stocks. It gets super interesting, and we'll hopefully do a video on it coming up. The third point is this idea that defendants engaged in fraudulent conduct. And so what they're basically stating here is that when you look at this Canada Life set of factors, this fulfills the second one, which basically states that there's fraudulent conduct or a probability of fraudulent conduct by the defendants. And here they're stating that there are multiple things. One is that they made these unlawful extortion threats basically against Stephen as Intrepid's founders, that they were, as they put it, playing fast and loose with company books and finances. Again, kind of going back to this idea of double counting debt and equity and things, which we'll try to do another video on. They go on to talk about how TFE Games attempted to divert the $4 million from Steam into their own accounts, bypassing Intrepid and Commerce West. And then also, lastly, they go on to talk about how they claim that TFE Games has deliberately filed false documents with the California Secretary of State to hide their own culpability or hide them from the public. If you don't know, what happened here was that the last sort of update statement of information, which you have to do every year, was actually one of the clues that something was going on because it was filed early and they don't normally do that. But it reverted John Moore back to CFO, which was apparently not actually the case. Apparently this whole time, from what we've seen, Ryan Ogden has still been CFO. So there's this claim that they intentionally did that. Stephen did provide email communications, basically stating, hey, this was wrong. Can you change it? And they have not. So now I don't know if they would or even could after all of the lawsuits going on, but that's one of the claims about it being fraudulent. And then the last point here that they raise is this idea of the balance of the equities supporting appointing a receiver, which would benefit Intrepid without really doing any undue harm to the defendants. It's their last bullet point. And again, looking at this Canada Life case, this would satisfy actually two of those. One is the balance of the harms, which was the fifth bullet point, and then also the seventh one, which was whether the plaintiff's interests will be well served by a receiver. And so here, this is a very basic argument. They're stating that the harm to the plaintiff and the absence of a receiver will far outweigh the injury to the defendants. So basically, more or less saying, hey, if the assets end up getting sold, that's essentially irreparable harm to the plaintiff or Intrepid Studios, while the defendants aren't really risking or losing anything if they have to wait while this plays out. Very, very similar to the preliminary injunction that we just saw some arguments about. So what they're basically stating that should a sale of Intrepid assets occur, a receiver would be able to ensure that such a sale was commercially reasonable and beneficial to all parties that are maintaining interest in Intrepid. So this idea of this balance of equities. So that is essentially what they're arguing. There's a whole lot of other exhibits for us to go through, but that is the sort of core of what they're trying to state. And that it satisfies all 7 points of the Canada Life case that we talked about early. So what comes next with all of this? Now that we know kind of where they're going, to me, this feels like a all or nothing play. They've put a lot of it out there. The preliminary injunction failed. I don't think they expected that to happen. And here we are. And so I think that's part of why we have so many exhibits, is this almost feels a little bit all or nothing. But the next steps are pretty straightforward. The defense, TFE Games, will get a chance to respond. After that, the plaintiffs or Stephen can respond to the response, and then we'll finally get to the judge reviewing everything and making a decision. Now, what will the judge focus on? I am not a lawyer, but I would say most likely, based off everything we've seen, is whether or not the company is at risk right now. Do you actually need a receiver right now? Because again, this is an extraordinary step, an extraordinary measure to put in place. And so that's probably one of the primary things is there a risk to the company imminently right now? Now, I do also want to point out that there are multiple possible outcomes. You don't have to have a full receiver put in place that has control of everything. You could have a limited receiver with only part of the request granted. That actually might happen. I mean, that actually was agreeable by TFE Games at the start of all this. So I could see potentially TFE Games having an argument that, hey, we're okay with a more limited measure, and then the judge going with that. But it could also be temporary, doesn't have to be throughout the entire course. And then they could just outright deny it, but then still put some restrictions. So there's several different possible outcomes. I think that most likely, because we saw TFE Games somewhat agreeable to a limited receiver, that we see something more along that realm. But yeah, a lot of stuff going on. We'll look at another video here, probably breaking down a little bit more of the financial stuff that's occurring. I do think it's super interesting. There's a lot of stuff here, guys. So if you're interested, keep following me. Make sure you follow, subscribe, and give me a like. Shout out to the other curators that are covering this with Nefis and Kira. Definitely go check them out as well. things are getting crazy, guys. This has been an absolutely crazy week. But we're here. Steven, you are talking a whole lot more. Offer still stands, man. You want to chat? We can chat. I don't think your lawyers will let you, but I'm here. All right, guys. I appreciate you. I'll see you next time.